Welcome to the Jury Thinks What podcast. Part of the Lawyer Minds ecosystem, the Jury Thinks What podcast discusses everything there is to know about trying cases, from preparing the case before the lawsuit is filed, all the way to trial. And most importantly, how to understand what the jury is thinking. During our journey, we'll be talking to some of the brightest trial lawyers from many walks of life. What makes them successful? What makes them different? Do they have secrets to dealing with the jury? Let's find out. Here's your host of the Jury Thinks What podcast, Saul Gruber.
And thank you for joining us for this installment of the Jury Thinks What, a podcast by trial lawyers for trial lawyers. My name is Saul Gruber, and as you know, I'm your host from Gruber Trial Consulting, and we are helping lawyers all over the country handle their cases. And the real purpose for this podcast and why we came up with this, along with the Lawyer Minds ecosystem, is to help lawyers with simple questions that they have. A lot of times people don't have mentors and they're going it alone, and this gives you an opportunity to listen to guests who are well-respected trial lawyers who are actually in the trenches trying cases. And that's our purpose here, is simply to help you. So, and of course, as always, if you have any ideas or questions, feel free to reach out to me and we'll try to address them in one of these podcasts. I'm excited. Our guest today is Sagi Shaked from Aventura, Florida, right around the corner from me here in Miami. I've been friends with Sagi for an awfully long time, and Sagi is one of the best trial lawyers I know. His motto is never take less than the full value of the case, and he will always try the case, as will his staff. That's something that we can all take a lesson from. So enjoy our interview with Sagi Shaked. And again, this is Saul Gruber from Gruber Trial Consulting with the Jury Thinks What. And today's guest is a pretty good friend of mine who I've known for an awfully long time, Sagi Shaked. Sagi is an amazing personal injury lawyer down here in Aventura, which is he's now my neighbor since I'm in Miami. Before it was just Jersey and Aventura. But Sagi handles large cases. And I know this because I have referred family members to Sagi. I know his policy is you never settle for less than the case is worth, which is really what we all want as lawyers to do. So Sagi, thank you for joining us.
Thanks for having me, Sal. I appreciate you, Sal. I appreciate that you brought me on, and hopefully I can share some knowledge and someone can take advantage of what I have to share.
Thanks. That's kind of the goal. And for those of you who don't know, Sagi is also, I think, president-elect of the Southern Trial Lawyers Association, STLA, a group that I've been going to for years. And it's a little bit different than AAJ and FAJ, Florida Association for Justice. And believe it or not, it's I think a little bit more prestigious. So congratulations on that. What do you think is going to happen with this year of COVID? Will you be elevated to presidency, or you think it's going to be one more year?
You know, that's an interesting question. We met with the board because of COVID. We were supposed to have our mid-year conference, which we did not have. That was supposed to be in October, and did not happen. And then we are concerned, New Orleans is a hot spot. So we don't know that this year, I don't want to speak for the board yet because we haven't made any decisions, but I kind of feel because of New Orleans and because of what I heard from the board regarding the mid-year conference, that we most likely will not have the conference in February of this year during Mardi Gras. That's what I strongly believe is going to happen. Hopefully we do, and they find a cure and everybody gets vaccinated by February, but 300 million people doing that doesn't seem likely.
And for those listeners who have not been to an STLA conference, it is in New Orleans. It is during Mardi Gras. It is something to behold, not just because of the Mardi Gras, but because the CLE, maybe the best CLE all over the country. There's just top people and talking in 15, 20-minute shifts, so it's incredibly interesting.
Yeah, you get every member's perspective, who's speaking, obviously. And what's good is we don't ask people for money. That's part of our bylaws. There's no fundraising, so this is strictly we're learning and having fun. So if you haven't been to an STLA event, especially the Mardi Gras event, you have to show up. It'll change the way you think about conferences, and you get to learn, have a lot of fun, and mimosas, Bloody Marys. It's a good time.
It really is. I've had the pleasure of speaking a few times and also attending, and it's a great time. So Sagi, Tell our audience a little bit about yourself, how you got into practicing law and getting to where you are today.
Sure. Ever since I was little, as far as I remember, and as far as, my parents always used to tell me that I always wanted to be a lawyer since I was a little kid. And then eventually I went to law school and started off wanting to do criminal defense. I didn't really like criminal defense. I liked the trial work, but I didn't like the dealing with defendants and going to the jails and all that kind of stuff. So I went to civil defense, and that's where I really got my feet wet in terms of learning the law from the defense side.
I didn't realize that. So you were a defense attorney.
I was, yeah.
That's incredible. Knowing you now, you seem like just the prototypical plaintiff lawyer.
Yeah, I always wanted to do plaintiff's work, but at the beginning, you don't know anything. Even when you're coming from the criminal side, you don't know anything, and it's kind of dangerous just to jump in to do plaintiff's work. So I went to the defense with a big firm. I think it's the biggest firm in the state of Florida. Worked there. Their motto that is sort of like, I guess my motto is now. I guess I adopted it. Any day that ends in the letter Y is a work day. So they killed us in terms of working. You'd start at 6 a.m. and you'd finish like at 10 o'clock at night, but you learned a lot. So
right.
I was there, learned a lot, learned how the defense really thinks when it comes to evaluating cases, when it comes to depositions, when it comes to medical examinations, trials, how the insurance committee evaluates a case, and how they do reports. So it kind of helped me a lot when it came to the plaintiff side, and I made that move.
One of the things you just mentioned, defense medicals, is something that we hear a lot. I know that when I was still practicing, even years before I was doing nursing home work, you would go into court and they were called IMEs, independent medical evaluations. Are they called that anymore, or they're straight DMEs now?
Well, a lot of the defense attorneys will still use the IME language, the independent medical exam. We try to ensure that they don't use that. So we always, in every case that we have, when trials coming up, we file a motion in limine to call them defense medical exams, not CMEs, not court-appointed medical exams, because the court didn't appoint that doctor. Right. It just doesn't look good if the court is appointing that doctor. It's a defense medical exam. That's what it is. And so we make sure that every case, it's never called an IME. They can put it in writing, but when it comes to the trial, right, it's always a DME.
Now, how important do you think the DME is when you're going to trial?
So this is where, especially on these, not the obvious cases. Obviously, when you have someone who's had an amputation, what's a DME? What's a defense doctor going to say? He didn't have the amputation? So these kind of DMEs are important in more of what you call either a soft tissue case or a case where there's contested causation, medical causation. So again, on the obvious cases, DMEs don't make a difference. But on the contested case, let's say you have a contested orthopedic case, I think the DME, the preparation for the DME, knowing everything about the DME, there's just so much into it that you really have to really prepare for that. It's not just go send your client and hopefully the client will do well. There's a lot more.
So you don't just send a letter to the client telling him what day to be there and say good luck. You do more than that.
Yeah, I would think that's malpractice 101. That's a way to get your case in trouble, a way to get in trouble, a way to lose a case, because any other lawyer that's worth their salt is going to tell the client, hey, why didn't the lawyer go with you? I would never allow a client to go to a medical exam without one of the lawyers from my office, whether it's myself or another lawyer in the office, attend with the client. Because think about it. The defense doctor is taking another deposition of your client. They could ask all types of questions there. So not only do we go with the client, we also get an order from the court before anything happens and it's very, very specific, and we'll go through the details of it later on, but I get an order prohibiting them from even asking questions regarding liability. They don't need to know about liability, and it's always granted. So that's not an issue.
Do you get that order in every case?
Every case.
Wow. So let's take a step back then. So now take us through the Sagi Shaked way of dealing with DMEs. You get the letter in from the defense attorney saying they want your client to see either an orthopedic, neurologic. What's the first thing you do?
So first thing we do, we either file, depending on the attorney, some attorneys in the office like to call it an objection to the CME or a motion to limit the scope of the CME, compulsory medical examination, or DME, defense medical examination. So that's the first thing. We'll give them dates, but the dates got to be after we get a court hearing or an order, a lot of times we can do an agreed order with the defense, because most of the times what we're asking for is reasonable things. Again, one of the things we would ask for is, you cannot ask questions of liability. This is not a deposition.
Right.
You want to ask questions about the medical side of it, that's fine. And again, in a deposition, they're going to attack your client about pre-existing conditions, and he failed to disclose that he went to this doctor and that doctor. That's why we don't allow that. You want to review the medical records, you can review them all you want. Also, when the defense sends that letter, they put the burden on us. If you have any medical records, bring them with you. I don't think so. I'm providing you the records, you provide whatever you want to the doctor.
Right.
So that's how I do that. So first, we file the motion to limit the scope of the examination to that person's specialty. And one of the things is, you can't go into liability. And that's in the order. So that's super important. That's the first thing you got to get in the order. Number one. Number two, you don't have to bring any medical records, any x-rays, any MRIs. That's on the defendant. Another thing that's extremely, extremely important, and again, you can go to the IME, DME, CME, but if you go there and you don't have either a court reporter or a videographer, and if you don't want to spend the money on a court reporter because it's not a big enough case, bring your own video or camcorder, put the tripod on and let it record. Just make sure you have the agreement in writing. I don't know what state a person's from, but in Florida, you're allowed to, so long as you give them notice that you're coming in with this video, and allow and record that. You want to put the onus on the doctor, have the doctor being filmed at the same time you're having the client being filmed, because then the doctor can't later on, 2 years down the road, when you're trying the case, at least in Florida, it takes that long. You know, you can show the doctor didn't do X, Y, or Z when they say they did. Otherwise, it's your word against their word, or your client's word against their word.
So you're actually getting an order allowing that videotape.
Absolutely.
And that can be done with an iPhone.
Yep, it can be done with an iPhone as well, yeah. Videotape and a court reporter as well. So both things they have to get into that order.
Now, given how expensive a court reporter is it ever acceptable to you to just use the transcript from the video?
Yeah, I mean, you can do that. Again, on a case, let's say you're trying an unoperated disc case or a smaller type of case, you don't want to have especially when liability is contested, you don't want to go crazy with the costs, because you can't. So just bring your iPhone or bring a camcorder, record, and that's fine. You can queue up the videotape or the digital video or whatever they call it now. I don't even know. You can queue it up, and if you need to, you can impeach it. You can impeach the doctor and say, hey, wait a minute, you didn't do that. Let's look at the video. So that's what I would use that for that purpose.
Are there certain doctors that will just drop out of the case on behalf of the defense once they know you're going to be videotaping them and a court reporter?
Yeah, I'll give you two examples. Today, actually, we had a prep last week and a prep yesterday for the client. So the client went today to the DME. One of the lawyers from the office here today went to this DME. It was of an ortho, really bad orthopedic injuries on top of a brain injury, but this was an ortho DME. We have the order in place already. We got the order. The order says we're allowed to be there. We're allowed to have our videographer. We're allowed to video it. We're allowed to have the attorney in the room. And because our client has a brain injury, we're allowed to have a family member of his in the room as well. And this order was granted about a month ago. So we get there. The defense doctor says, I'm not allowing anyone with a video in the room. I said, well, we're not having the DME if you don't allow the videographer in the room. Finally, he gets on the phone with the defense lawyer. The defense lawyer tells him there's an order that you have to comply with. By the way, one of the things we put in the order that the defense has to inform the DME of the order, which obviously they didn't do in this case.
Right.
So you have to tell them about it. You have to tell the defense doctor, meaning the defendant has to tell the defense doctor. And now they agreed during today's DME to allow the videographer in, but they didn't want to allow the lawyer from my office. They said, you can wait out in the hallway. So of course, we objected to that and said, no way. And the reason you say no way, because you can't allow your client to be questioned by a defendant lawyer or a defendant doctor. That doctor is not on your side. They're not going to do anything beneficial to you. So who knows? In the hallway, I'm not going to be able to hear anything and can't protect my client. So the defense doctor refused. So we got on the phone with the defense lawyer, informed the defense lawyer, if this doesn't go forward, we're billing you for our time. We're going to move for sanctions for the lawyer's time, the co-reporter there, and the videographer there. So, of course, it didn't go through. So now they're going to be on the hook, and it's it's a huge case. So they've got problems. So that's what we're going to move forward, and I guarantee you we're going to get sanctions because this doctor didn't follow a judge's orders.
Right.
So that's the way that happened. I'll give you another example.
Sure, that'd be great.
So we had trying to remember now, it slipped my mind. Where was the other one? I got to come back to it. It slipped my mind.
So let me go back. So you have the court order. You do that first.
Yes.
Now you know it's going to happen. Is there anything you do with regard to the defense attorney to remind them as you're getting closer to the DME that you're going to have a court reporter there, a lawyer there, and a video there? Or you just rely on the record and the order?
I rely on the order. I mean, maybe now in hindsight, what happened today, maybe I should send them, hey, ensure, I have to tell them to do their job. Ensure that, we can get there because we don't want to waste any time. But the order is clear enough. I mean,
it sure
it
sounds
says in
like
the
it.
order. They have to give the defense doctor notice of it. Yeah. So, I mean, that's one thing that we definitely make sure. And then another thing that you can put in the order, this is important, that the video is your work product. And you're not going to produce the video to defense counsel. So what I would do, unless you're listing that video in Florida, I'll speak specifically for Florida.
Okay.
Something doesn't, if it's work product, and as long as you, prevent it from being disclosed, if you don't list it on your witness and exhibit list, then that doesn't make it to the jury and they can never use it. So long as it's work product and you didn't waive that work product privilege, you don't have to give it to the defense. And I put that in the order, and that's usually granted as well.
So really, before whoever's listening to this puts this into play, they really have to understand what their law is in their state regarding video,
correct,
court reporter, and about evidence.
Correct. Now, I also, go ahead.
So now you get the order. What's next?
So one more thing. In the order, I ensure that they don't do any type of invasive testing on my client. Think about it. If your client's been to the hospital, they've been to the doctor, they've had radiation, whether it's coming from the CT scan or the x-rays. So, we at MRIs don't give radiation, but if they've had a bunch of x-rays, the last thing you want to do is continue to give them radiation. So I ensure that the doctors don't take any x-rays. We put that in the order as well. The doctors are going to have to rely on the other x-rays that have been taken in the case.
It's funny that you say that because I can remember back years ago, where we weren't as smart as you and we would just simply send our clients to the DME, and then you would get the report back because the client wouldn't even call you to say what happened. And in that report, it would say, I was a little concerned about what the MRI showed, so I sent him over for another MRI, and now it's clear that there's no herniated disc. And we would look at this report dumbfounded that A, that would happen, B, who paid for it, and C, how did my client forget to tell me that?
Right.
So your way is a good way to ensure that can't happen.
Right. Yeah,
now,
I don't want that to happen. And then one more thing that we do is we make sure that we get this report within 30 days. I put that in the order as well.
And why is that important?
Well, I don't want to be sprung on last minute, even though there's court deadlines. We all know, and at least I've been in this situation, a deadline's not really a deadline. Unless you're in federal court, a deadline's not a deadline. They give it to us last minute, and then the court will say, well, you still have time to analyze it, or, let's continue the trial another 6 months. So I want that report within 30 days. I want all their opinions. I want them in writing. So when it comes time to cross-examination, I know what their opinions are. I don't necessarily take the DME doctor's deposition because why give away where I'm going? It just depends on the case. Every case is different. But I think, the last maybe 10 trials, I didn't take the DME's deposition because, again, I know what he's going to say or she's going to say. It's in the report. It's supposed to be detailed, and they can't really go outside of the report. That's what our law says, at least.
Yeah, and even if the court lets them go outside of the report, there's always the cross-examination that, this isn't your first report that you've written. You knew that it would be relied upon. And this opinion you just offered to the jury, you intentionally didn't put it in that report, correct?
Right.
Yeah. Something along those lines. I kind of agree with you on not taking the defense medical expert's deposition. I think, you're not only are you telling them what you're going to do, but you're helping prepare them for trial.
Yeah, you showed where they made the mistakes, so I don't do it anymore. I used to, but I stay far away from that now. Unless, of course, it doesn't happen often, and you have such a horribly injured client where the defense doctor is giving you in Florida, they give you permanency and causation, then I can move for summary judgment, take their deposition, move for summary judgment. I don't have to deal with those issues anymore. Right. But it's rare. It doesn't happen. Those cases settle fast.
Well, so I used to laugh, with the nursing home cases that, I used to try a lot of, there's only so many defenses their medical expert can have. Right. If it's an administrator or a nurse, right? There's only so much they could possibly say. It's not something we're not going to be ready for. So what was the difference? We used to get reports, so that would at least box them in. There was no reason. Right. But in states, there are states out there that not only don't you get reports, you don't even get depositions. You find out literally at the last minute who the people are going to be. That's interesting.
Yeah, that I've never encountered. That would be completely. That's like trial by ambush.
Yeah, and I think it was either Washington or Oregon. One of my clients, were trying the case, and they found out who the expert was in the pretrial memo, and what the expert was going to say, and there's no reports. Really, really crazy.
Yeah, that really gives you no time. That's like federal court stuff, right? But even in Florida federal court, you still have the right to get your report in a timely manner, get it analyzed, reviewed, and that kind of stuff, and prepare.
So now someone's listened to you and they've gotten that great judge's opinion. What do you do next?
Okay, so now you need to prepare your client. Again, because the defense does get to ask the plaintiff, your client, questions regarding the medical side of it, you have to really prepare your client on the medical. Of course, if your client is brain injured and can't respond for themselves, that's a different story. But we're talking about the average orthopedic case, for example, or a neurological case unrelated to a massive brain injury. But if you have a client who's responsive and can talk and has an orthopedic injury, they need to know what their injuries are. For example, if you have a herniated disc that's impinging on the right, so you expect to have right-sided pain, right? We expect the medical records to show that the person has right-sided radiculopathy. Now, it can happen where you can have what they call the contralateral kind of issue, where you have left-sided pain too.
Right.
A little odd, and that's where, the defense will start using the dermatome charts and start, creating issues in the case. Doctor, does it make any sense that, someone who has a right-sided herniated disc is having left-sided radiation? And they're going to say no, and here's why, and they put the dermatome chart. So we want to make sure that our clients they're consistent with what their medical records say. So we do it's like preparing the client for a deposition. This isn't, go in there and, you're going to do great. Never, again, you're not sending the client alone. You're going to prepare them. You're going to get all your records. Make sure you have every single record. Not only every single record, but every administrative record within that record. So a lot of times, the medical providers will put stuff, especially if you have what they call a letter of protection on the file. They're going to have that in the administrative section. These doctors are asking these questions. You want to find out everything that's in the narrative of all the doctors. Go over every single record. And no, it's a lot of work. But if you're putting someone's case into litigation, you've got to put in the work. This isn't an easy field we went into. You have to put in the work and protect your client. So first thing is, after you've gotten that order, sit down with your client, go over the meds. That's the number one thing. So
now, do you send them a copy of their complete medical record and ask them to read it, or do you simply go over the highlights with them when you're meeting with them?
We meet with them in the office. Now it's COVID, so we meet with them by Zoom, the ones that can do Zoom. Some of our clients are not technologically savvy, so we still bring them into the office, and we go over those records. We highlight certain things in the records, and we don't do it the day of, and we don't do it the day before, because, again, clients are not going to remember, and you've got to test them. A lot of times you'll see little tricks that these doctors do. Your client says they have back pain. In the waiting room, these doctors have video cameras. So they see what you're doing. They'll have someone purposely walk by you in the waiting room, and they'll drop a pen to see, oh, your back hurts so much, but you're able to pick up this pen with ease. Or if your client is a female and she's going to the defense doctor and she's has back pain, do you really want your client showing up with high heels? Not a good decision, especially if you're claiming back pain. It's hard enough to walk on heels, and then you have back pain. Not a good issue. They're
And the defense doctors never miss that.
They don't. They always put it in the record. She came in with heels. Women want to look sexy, and I get it, but it's not good for your case. So we do that as well. We also monitor their Facebook. You can't tell people to erase stuff because that would be a spoliation of evidence or evidence destruction, but you can't tell them not to put stuff on Facebook because the insurance companies are looking at that. And for the younger crowd, at least right now, we know there's Snapchat and TikTok. Who knows what'll be there in a year from now or 6 months from now? There's always something new. You really got to watch what you're putting on these sites. While the defense doctor is not looking at it, the insurance agent and defense lawyer are looking at that stuff. Anything they can to hurt your case.
Yeah, they definitely are. In fact, one of the things that we used to do when the clients first came in was all of our offices have internet, right? That's how we're doing this now. We would go on their Facebook or LinkedIn and just see what's there with them and explain to them. Now, could you imagine if a jury saw that? Or could you imagine if someone an insurance adjuster would see this? And again, you don't ask them to erase anything because you're not allowed to, but you just want to educate them on what they should be doing with their social media.
Yeah, we definitely do the same. So, and part of that is when you have the person, again, come to your office, before they meet with me, what I have them do is watch a video of what a DME looks like.
Okay.
And what the person goes through. And it depends. There's videos specifically for shoulder, for example. Just doing shoulder. There's videos for spine. There's videos for knees on what kind of tests the doctors are going to do. So we have them watch the video, and then we go through the medical records.
Did you prepare those videos, or did you purchase them from a vendor?
I purchased them from the vendor.
Okay.
It's a good idea, though, to actually have myself do the videos because then they can watch it and get my perspective on it. I like that idea. I'm actually going to do that. That's a good idea.
You could say inspired by Gruber Trial Consulting. Not a problem.
That's it.
Now, where would someone, if someone's listening, is there a particular vendor that that has those type of videos?
Yeah, I can get you the name in a second. I just have to get up and get it.
All right. Well, you know what? I will be able to put it to, so if anybody wants it, they can contact me or Sagi and we'll get it out to them.
Yeah, and if anybody needs like a sample of the motion to limit the scope of the defense medical doctor, I'm willing to share. Just email me and I'll get it to you, and I'll send you a copy of the order as well. You can use that as well to show other courts, hey, this is what the courts are doing here. We need to put the brakes or the kibosh on this. Like if you have, for example, a neuropsych, they hate the neuropsychs. The defense neuropsychs hate when someone else is in the room. So you've got a client who's brain injured, and they're going in for a neuropsych evaluation, and I get this order right away at the beginning for all CMEs, right?
Right.
So now you have it for all CMEs that we can attend with a videographer, a co-reporter, because what they've testified to in the past, at least the ones here in Florida, that when someone else is in the room, it invalidates their entire opinion, because that's how they try to get you out of the room. But here we go. We have an order saying we can appear in the room. So now when we go to trial, you're going to say, you can ask them and say, well, wait a minute, if someone's in the room, that invalidates everything that you say. And you'd agree there's a videographer in the room. We have the video. I was in the room. That's one way to attack it. But I always want to bust their chops. If the defense is fighting, against it, I want to fight against it too. I want to go against whatever they're doing. When you have a neuropsych DME, you want to ask for that raw data. And that's also a completely different topic and a whole,
right.
That would be a podcast in and of itself to deal with brain.
Because normally they give us their conclusions based on the raw data, but we don't ever, without an order, we don't see the raw data, which really tells us what's going on with our clients.
Right, and you can put that again in your order as well. So I have an order specifically for the neuropsychs, but then I have this more like broad order for all the CMEs. If I can get the broad order going first, that's great. And if I have to go for the CME, then I'll get the neuropsych, I'll get the more specific order.
I'm so fascinated by these orders. I'm assuming even when you get them, sometimes when a doctor says, I'm not going to follow them, the defense will file another motion saying they have a right to pick the defense doctor they want. And here's an affidavit why the doctor won't allow a court reporter or video. Have you dealt with that? And what does a judge normally do?
Generally, the only times we really deal with that are in the neuropsych IMEs or DMEs. They're the ones who really fight that issue. They do file the affidavits that it interferes with their testing. And again, we're not interfering with their testing. I'm just making sure that they don't violate anything
Right.
or ask my client questions that are, improper. So we've had some DMEs where they put you in another room where you can be, there's a glass and you can see the DME going forward. The videographer's allowed in there, but nobody else is.
Right.
But you
Yeah,
have
because that neuro, from what I recall, it's really a lot of times maybe 6 or 8 hours of testing.
Right, usually over a couple of days, because it can
Right.
burn someone out who's not used to sitting there and taking tests all day long. It can burn someone out. So 2 to 3 days, about 6 to 8 hours is right. 3 hours at a time.
So you've got the order. You've now had your client see the video on DME. You have the records highlighted, and you're going over the records with the client. Is there anything else you're doing with that client to prepare them for the DME?
Sure. If, for example, the court, this is another suggestion, if the court does not allow you to prevent the doctor from asking questions, then what I would do is, and this is also in the general order, I want to get any forms that they require my client to complete ahead of time. And we're completing them in the office. I'm not doing them the morning of the DME or the afternoon of the DME. I'm doing them in the office. I'm attaching, all types of medical records, so specific author, the ortho, the surgical records. Here's the specific detailed, what the procedure was done.
Right.
And I always put in there, to the extent I forgot to list something, please see all my medical records. So you don't want to, because then they go and they pop open this one document. See, here's the highlighted diagram of the individual. He only circled that he had back pain. He didn't put that it was radiating pain. So, but if you're there and you know the medicine and you know what your client went through, that's not going to happen to you. So it's the same.
And that's really what happens in every case, right? They deny referred pain, or they denied any problems going down their leg. Anything that would make it more serious. Interestingly, when they go to a DME, our clients denied it, even though they admitted it to every other doctor and the deposition.
Well, that's why you have the video. You keep them honest.
Right.
That's why if you're filling out those intake forms, it's not another deposition of your client alone. If your client goes alone and they're filling it out, they don't understand. They don't think it's a big deal, but all these little things add up. Like, for example, unrelated to a CME, we had a trial. Client came to us 6 months after the accident. She had been treating on her own. She filled out the PIP application. So in Florida, we have personal injury protection. Some states have it, some states don't. And they require you to fill out this application for benefits. And in the application for benefits, it says, please state the nature of your injuries. And of course, she only put down neck pain. She didn't put back pain. She didn't put down radiating pain. And that's weeks before the lawyer got involved in the case. And lo and behold, that thing beat the size of a billboard in the trial. Your back was so hurting. And when you filled out this application, you just put neck pain, and you didn't put anything about back pain. So they're looking to hurt you with the stuff that your clients complete. So anything that a defense doctor is going to make you complete, you want to look at it ahead of time. That includes also your treating physicians as well.
Yeah, absolutely. The treating physicians is just as important. I've always been fascinated by the extent that our own insurance companies go to harm us. I mean, they're supposed to have some sort of fiduciary duty, right? It's first party benefit. Yet they treat everybody as an incredible adversary, and all they want to do is not pay us benefits, even though we paid our premiums and never missed a premium.
Right. It's all about protecting the money. They're going to do everything possible, put hurdles. That's why people get frustrated. They're like, I need to go to a lawyer because it's just too much paperwork to fill out. And they're right. Don't fill the paperwork out yourself. Go to someone who knows what they're doing. If you go to a novice who doesn't know what they're doing or who hasn't been in trial and hasn't seen, some attorneys might say, it isn't so important. You don't need to do all that. Mm-hmm. Well, if you've been in trials and you've seen the errors, you know why you want to get that court order, why you want to fill out those forms. You don't want to have an issue like that harm your case, because then the defense, when they come out and fill out was their negligence on the part of the defendant, that was, here's the key word, a legal cause, right? Of injury. And they say there wasn't a legal cause of injury. That's the problem. I see it, once a week, at least when we were trying cases, because now there's COVID, but when we were trying cases, people are losing rear end cases. You see it. It's in the newspaper every week, losing a rear end case. Why? Because I think the causation aspect, people aren't getting with their clients and preparing them on it.
There certainly is nothing worse than sitting in a courtroom and watching that big as day statement, not injured. just wanted to let you know that I was in an accident, and they take a statement, and then you find out later, and now you're at trial. It doesn't matter how much you explain, the jury's going to see not injured, and was not going to get past that not injured. It really is that important.
Yeah, it's painful too. You don't want to be on that side, so you got to do everything. Yeah. That's why everything you learned in all those years of trial now comes, and you want to help other people, because you don't want anyone else who's, if they're injured, they deserve to get compensated. You don't want to see them, get screwed by a defense attorney or an insurance company. So we try to teach everybody, and you're doing this podcast, which is awesome for all lawyers, whether you're a seasoned lawyer or a non-seasoned lawyer. You can always learn something. I'm always learning, even from younger lawyers and from lawyers who are, older than me or have more experience.
I learn from some people, because now my lawyers are my clients now, so I'm no longer really representing people. It's incredible how much I'm learning on a daily basis, and it's fun. I mean, it's actually fun for me now. It was fun for me for a while then too, but after the 30th year, it gets a little tiring.
I get you.
But I'm fascinated. So, I mean, it sounds like you're doing, and your office is doing, a ton of work going into the DME.
Yeah, it is. If we're putting a case into litigation, like I said at the beginning, we're going to work that file. I just don't put a case into litigation just to put it into litigation. If the case is worthy of putting it into suit, it's worthy of you working your butt off and making sure you do the best for your client. Because after all, it is your client's day in court, right? But it's also your name. And if you're proud of your name and you want your name to mean something in the community, in front of judges, in front of other lawyers, you better do a good job. And so nothing but excellence is what I preach here. You've got to be excellent at what you do, and you got to put in the time. There's no shortcuts. Really, there are no shortcuts. Put in the hard work, you're going to reap the benefits. You don't, you're going to see the results.
So we've got the order, we've got the meeting with the client, go over their medicine, show them what to expect. Do you do anything else before the DME?
Aside from them watching the video, for example, if they have a herniated disc case, the straight leg test, for example, in that video, it shows them what a straight leg test is, so they know what to anticipate. So aside from preparing with the client as if it's a deposition, it's sort of another deposition.
Sure.
Going over those medicals, we do attend the defense medical exam, and then also on top of having the order, we do send out a letter to defense counsel once the medical exam has concluded. We let them know, hey, we attended the medical exam. Please comply with the order and get the report to us within 30 days. Because I don't want to waste time filing. It's a standard boilerplate letter that we have, but it's still got to go out. If it doesn't go out, yeah, they have to comply with the order, but who knows if they calendared it, and if we don't calendar it, it gets lost in the shuffle, and trial's coming up and you don't have it. So I put the onus on them. Hopefully we don't have to file a motion to compel to get the order, to get the report.
So let's jump forward just a minute, and then so now you've got all this information, you're going to trial, and now the DME comes in and he testifies, or she testifies, and it's contrary to what the video shows. Has that happened?
Yeah, absolutely.
And what are your options at that point as the plaintiff lawyer?
Yeah. So first, when we're going to trial, I know everything about the DMEs, because generally it's the same players you see all the time.
Sure.
These are the defense, we can't call them hired guns in court, but that's what they are, right? So I get every transcript that I can find. There's a Trial Smith, I think, has it online where you can pull up
most of the state TLAs use Trial Smith.
Right. And then you have your local ones, like here in Miami-Dade County, we have the Broward Justice Lawyers, the Miami-Dade Justice Lawyers. You have different people on listservs who keep transcripts, who's trying cases or not, and everybody shares their transcripts. So we can have a nice, body of transcripts that we can use to impeach the doctors on. So, but going back to your question with the video, if the doctor says something different than the video, yeah, I would definitely impeach him. I would bring up that video and use that against him. We had a doctor, for example, very well-known defense doctor. He actually lives in my neighborhood, which is funny because I see him running. And we always joke about this because I have had him in trial 1 year, I had him 4 times in trial. But in his report, he wrote that it was a bilateral herniated disc. And in that case, he saw my client twice because my client had seen him for one surgery. He had the surgery, then had the DME, and afterwards had another surgery. So then he had a second DME. So now they had 2 DMEs, and both times that the orthopedic saw the MRIs in his office, he called it bilateral herniated disc bilaterally, meaning impinging on the nerve going down both sides of the legs. Now, fast forward to trial, the orthopedic is getting ready to testify. We're having some motions in front of the judge. In the meantime, both the radiologist and the orthopedic are outside. The defense radiologist and orthopedic are outside. And I think they got together with each other because the radiologist, he said he read the film and he only said it was right-sided herniation. So now we're in trial. Radiologist has testified. He leaves. The defense ortho, this is the same guy that said it was bilateral in his reports, now is testifying. And he testified, and he starts saying bilateral. So now I get up on cross, and I had a chance to think about it because I'm like, I can't believe this guy's doing this. And I'm like, Doc, let me see if I got this right. You went up there, you put it on the view box. We were using view boxes when I first started practicing. You put the film on the view box and you circled it in red and you showed that's a bilateral herniated disc. A right-sided herniated disc. He goes, yes. So I asked the doctor, if there was another physician that looked at those MRIs in his own office and he said that was a bilateral, impinging bilaterally, you would say, you'd look this jury in the eye and I held up my finger, you'd say that doctor's, 1, he's inaccurate. Number 2, that doctor's not telling the truth. And number 3, you got to tell this to the jury. You're gonna look this jury in the face and you'll tell them that what that doctor said, you don't believe a word he said. You're gonna do that, right, Doc? Well, if that's what a doctor said, because I don't see any way possible that happens. So I go, Doc, but if it happens 2 times where the same doctor 2 times in his office read it as a bilateral herniated disc, you would still look at that jury and say, inaccurate, mistaken, and don't believe that doctor. And he said, yes, that's what I would do. So I'm like, doctor, let's look at your report.
Oh, God.
You were the doctor who said that it was bilateral. So I pull up the report on the big screen, and his face turned red, and the case settled right after that. It was
a lot of us don't get those kind of cross-examinations. That was a lot
of fun. So I have that on a transcript if anyone's interested, because it's a great read. It is a great read. But that makes trial fun. That makes where you really know the file. And again, going to the DME, you've got to know the medical records. If you don't know the medical records, don't rely on your clients to know the medical records. They don't know anything. They just know they got hurt. They don't know the details of how the cross is going to go. It always goes on these collateral items that don't make any sense. But that's why you've got to know the medical records. You've got to know the file, everything in the file, from the MRI reports to the medical records when you go to that DME. And it helps out. You can see the difference when you try the case. I didn't know more medicine than the doctor, but I know he was lying, and I know that didn't make any sense what he was saying. So,
well, Sagi Shaked, thank you very much. That was incredibly informative. I really appreciate you helping all of our listeners and helping me with some great information. Thank you so much.
Thanks for having me. And then if anyone has any questions, I love helping. I love giving ideas and sharing ideas and bouncing things off each other. So I'm always here to help.
How could they, what is your email that someone can email you at?
Yeah, the email is Sagi. So that's S as in Sam, A as in Apple, G as in Google, I as in Internet, at Shaked Law. I think you can see it on the screen down there. That's SHAKEDLAW.com. Any questions regarding DMEs or anything in general, I'm here to help. I like helping.
Thanks again, Sagi.
And I'll share everything.
We really appreciate it. Thank you.
All right, you're welcome. Thanks for having me.
Wow. Again, this is Saul Gruber from Gruber Trial Consulting, and you're listening to the podcast, The Jury Thinks What? On the Lawyer Minds ecosystem. Our guest today was Sagi Shaked. Just incredible information Sagi gave us with regard to getting a court order allowing the plaintiff lawyer to both go to the DME as well as videotape and record it and limit the questions that can be asked. Some real informative stuff, as well as how he and his office prepare the client for the DME. Again, like he said, if you're not willing to put the work in, don't put the case into suit. I think that's phenomenal advice. Thank you, Sagi. And if anybody, Sagi was really nice in saying if anyone wants any information from him, if anybody needs any forms, he's happy to give them to you. And he gave you his contact information. You can always contact me here at Gruber Trial Consulting, and we're happy to put you together with Sagi. It's now that time in our podcast for the Nursing Home Minute. And one of the things that we see a lot from people trying nursing home cases is, how do we prove the standard of care? How do we show what's supposed to happen? That's sometimes one of the most difficult things we do in a medical malpractice case. However, in a nursing home case, it's different because we have the federal regulations, and you're going to be using them throughout discovery and having the defense witnesses confirm how important they are and that a nursing home must follow these regulations. But here's a tip for when you're at trial. Make sure you have more than one set of the regulations. Keep them around the courtroom. Keep them at the witness stand. Keep them very open on your desk, and keep them, there's always a little desk by the jury. Keep them there. That way, anytime you are talking about the regulations or anybody references those, you can say, you mean the ones contained in here, and lift the book up. If you get the book from ahca.org, it's also called the Watermelon Book. It's very obvious what it is. And by doing that, you're in essence anchoring that book to what's supposed to happen, which can really pay dividends throughout the case and in your closing argument. Again, thank you for joining us for this podcast. It's The Jury Thinks What. I am Saul Gruber from Gruber Trial Consulting. Look for our station on YouTube where we put out every Wednesday either a trial tip or a nursing home minute. And again, if you're watching this on YouTube, go to Apple Podcasts or anywhere you get your podcasts to subscribe to The Jury Thinks What and all the other podcasts on the Lawyer Minds ecosystem. There's some incredible information that you won't be sorry. And I look forward to seeing you again next month. Thanks.
That concludes another episode of the Jury Thinks What podcast, part of the Lawyer Minds ecosystem. Thank you for listening, and we truly hope it was worth your time. Please consider subscribing to the show wherever you listen to podcasts. Explore the other content that Lawyer Minds has to offer, and engage with us on social media. Your feedback and ideas are always welcomed. See you next time.